Welcome, everyone. My name is Andrew. I'm the founder and owner of Ibis Prep, and today I'm doing the complete review for the uniform bar exam for the July 2025 administration. I'll be going over some pointers for the MPT and then all of the MEE subjects. Starting with the MPT, my advice from personal experience is to be very mindful of your time. The most important thing is you allocate appropriate time for each response. Time moves faster on test day, and you don't want to be in a situation where you have no time to write your second MPT because you took so much time on your first MPT. So, be faithful with your practice, and on test day, just put on the brakes when you are, at an hour or just over an hour and a half, right? When you're at an hour and a half or just over an hour and a half, put on the brakes and get to your second MPT. That's my best advice from personal experience is that time moves faster on test day, and you want to allocate equal time to both MPTs to feel really good. And you start with the MPT in most jurisdictions, so you want to start off feeling good. So make sure that you're mindful of your time. When it comes to your responses, the advice that I tend to give is more writing, less reading. And I know in the practice they'll tell you opposite. Be very careful with what you read, underline and read things thrice, and really make sure you know what you're talking about before you get to responding. Henry David Thoreau, how vain it is to sit down and write when you have yet to stand up to live, right? But in this context, I think you got to spend more time sitting down and writing and less time standing up to read the material. What I mean by that is just read it as quickly as possible and just try to take from it what you're going to use in your response. You're not here to give a sophisticated, creative, thoughtful analysis. You're here to piece together the information they gave you in the structure that you're supposed to write it, that you've been instructed, and write as many words as possible and get as many rubric points as you possibly can. So I really encourage people to spend less time with the careful reading and more time with the actual production of what's going to be graded, and try to spoon feed it to the reader. Issue, rule, analysis, opposing argument, conclusion. Make the headings to be aligned with the instructions. This should be the part of the test that you feel good about. You don't need to study any material to memorize. You just need to practice and have a great execution on test day. Remember, the more you write, the more opportunity you have to get a passing score based on getting rubric points. So I encourage you to write as much as possible and just keep up the good energy. So how should you approach the MPT? There's a lot of different ways what you should read first or last. I'm not going to change anyone's mind right now, but what I will say is try to incorporate something from everything that's presented to you. If there's depositions, if there's emails, if there's cases, if there's statutes, use something from everything so that you can really touch as many rubric points as possible. And from the cases especially, take the rules and take the elements of those rules and then apply them to your facts. In the case presented, right, in Tommy v. Johnny, the rule was established X, Y, and Z. In that case, quickly, this is what occurred. Here, in our case, the facts are substantially the same, which is why we should likely arrive at the same conclusion. Or compared to this other case that they gave us, where the facts were XYZ, our facts are substantially different. Therefore, that holding should not apply here. Therefore, on balance, the court should likely find, right? Like just being very methodical and presenting for the reader to enjoy, right? Like imagine you're working at a restaurant and you're serving a platter, right? You want to make sure the edge of the plate has been wiped off, and the vegetables and the protein, they're all separated nicely. Like, right, it's presentation. When you're writing the MPT, it's about taking the material that's given to you, synthesizing it quickly, and then presenting it in a easily digestible manner that follows the instructions. And when it comes to getting points, the more you write, the more likely you are to get points. So try to just use as much from the uh, facts as possible and from the cases as possible, but also do a fair amount of analysis, right? Here, the facts were this, but in our case, the facts are that. Therefore, the court would likely find. The next one, consider the statute. These are the rules from the statute, and our one side would argue this, the other side would argue that. In consideration of the language, this is the likely conclusion. A lot of IRACs, issue, rule, analysis, if possible, opposing argument, and conclusion. And I think you'll do just fine. If they ask you to write it in memo form, write it in memo form. I mean, I think a lot of people, it's like, oh, the MPT comes and you get nervous, and then you take a long time doing your little introduction and all that. I would advise people to just get right to the response, as quickly as possible. I'm not saying don't do the reading. Like, you have to read everything and you have to, like, figure out what's useful, but don't read it as if it's like a case that you're going to trial. Read it as something that you have a very limited amount of time to work with, and you have to take as much from it as you can to craft this response that's going to get you as many points as possible. And once the time for the first MPT runs out, move on to your second MPT and you start fresh and give it your best effort. It's a significant part of the exam, so don't overlook it. And I think it's really about execution more than anything. Just be in a good mind state, feel good, look good, test good, and everything should go well on the MPT. Um, as far as word counts, like 2,000 words would be amazing, but don't be obsessed with word counts. As far as different types of MPTs and different ways to address them, we had the lecture. I'm not going to go into all those details, but what I would say is just follow the instructions. Don't try to write a response that's creative. Write a response that exactly is formatted as you're instructed to. So for the MEE, I'm going to go subject by subject. Let's start with contracts. Contracts, UCC versus common law, UCC for goods, which are all things movable, and common law for services and land. Formation is offer, acceptance, and consideration. Offer is a manifestation of intent to be bound by a contract that gives the power of acceptance in the offeree, and the acceptance is that manifestation to be bound, and it includes mutual assent and a meeting of the minds. There can be, some issues at formation, like the mirror image test under common law, where the acceptance must match the offer exactly, or the battle of the forms provision under the UCC, where between merchants, if there's an additional term and it's not material, it will be included in the contract. If it is material, it will be knocked out, and UCC gap fillers will apply. There could be the mailbox rule, where there's an offer that's an effective upon receipt and an acceptance that's effective upon dispatch. Or there could be, invitations to deal or counter offers. You really have to look at the facts and see what's going on in contract formation. It's also important to understand different types of contracts, like a unilateral contract, a bilateral contract, an options contract, a requirements contract, an output contract, an installment contract, a divisible contract, or a quasi contract. It just being familiar with different types of contracts will help you answer these questions. Remember, an installment contract usually has an opportunity to cure in the event of a non-conforming shipment. A bilateral contract requires contract formation, where a unilateral contract can be accepted by performance. Breaches are important. Even before breach, you want to think about defenses, like defenses to formation and defenses to execution. The statute of frauds applies to contracts that are in consideration of marriage, contracts that cannot be completed 1 year, contracts for land, executorships, goods over $500, and suretyships. Exceptions to the statute of frauds include specially manufactured goods, the written confirmatory memo rule, admissions in court, promissory estoppel theories, and performance. So other defenses include mistake, unilateral or mutual mistake, fraud, duress, misrepresentation, illegality, illusory contracts, incapacity, intoxication, infancy, unconscionability, procedural and substantive, undue influence, impossibility, impracticability, frustration of purpose, latches, acquiescence, unclean hands, right? Understanding what all of those defenses mean could be helpful. And then breach, right? Material or immaterial breach or anticipatory repudiation when one party unequivocally demonstrates an intent not to honor the obligations of the contract. There could be a material breach, which goes to the heart of the contract, or an immaterial breach, which is more minor. And then, of course, there's damages, legal relief and equitable relief. Legal relief are monetary, like expectation damages, consequential, incidental, reliance, restitution, liquidated damages, which must be reasonable and cannot operate as a penalty and are calculated in advance because they'd be too speculative in light of a breach. And then equitable relief, like specific performance, reformation, rescission, quasi-contract, promissory estoppel, and injunctive relief. Modifications need consideration at common law, but not under the UCC. The parole evidence rule bars the admission of extraneous evidence that contradicts a contract, but not to show conditions to contract defects in formation, to clarify ambiguous terms, or to show custom, trade, or usage. There's the firm offer rule where a merchant, if he puts in writing an offer, it doesn't need consideration to remain open for the stated period or for up to 90 days if not stated. And then typically non-competes must be reasonable in geographic scope, in subject matter, and in duration. And third-party beneficiaries, intended versus incidental. Intended beneficiaries are named to benefit in the contract and they're contemplated and they can stand in the shoes of a party and assert the rights, whereas an incidental beneficiary doesn't have any rights under the contract because they were not intended to benefit from the contract. Yeah, contracts is manageable. I think everyone should do pretty well with contracts. I don't see any issues with contracts for anyone because if you're taking the MBE, it's very much the same, right? It's the UCC, it's the common law, and it's my mnemonic for knowing all the issues is buy friends drinks, big drinks, body of law, formation, defenses, breach, and damages. And if you can remember those categories and have good definitions for the different terms, I think you'll do just fine in contracts. Torts, first off, negligence, duty breach, causation, damages. Causation can be actual, must be actual and proximate. Actual is the but-for causation, whereas proximate is the foreseeable plaintiff or the zone of danger. So there could be negligence per se, where a statute creates a duty of care. There's res ipsa loquitur, where the thing speaks for itself. The injury wouldn't have occurred in the absence of negligence, and it's under the um, you know, uh, exclusive control of the party, right? The injury causing instrument, let's say. Uh, there's strict liability claims, which could be for wild animals, inherently dangerous activities, or products liability. For products liability, there's strict liability theories of manufacturing defect, design defect, failure to warn, inadequate warning, implied warranties of merchantability and fitness for a particular purpose. A design defect is when it fails the risk utility balancing test or the consumer expectation test. The UBE, they also test, I've seen this concept of market share liability, where if multiple, let's say, companies produce a fungible good like a pill and it causes injury, they can assign liability based on the proportionality of production. fungible means they're all the same, right? If they're all the same good. That's the market share liability theory. So premise liability, consider if they're a known trespasser, an unknown trespasser, a licensee, or an invitee. Invitees are the business guests who are owed the highest duty of care. Um, think about defamation. So defamation is either a public or a private plaintiff. A private plaintiff is mere negligence, but a public plaintiff requires actual malice. Slander is spoken and um, libel is published. And then there's intentional torts, assault, battery, false imprisonment, trespass to land, trespass to shadows, conversion, intentional infliction of emotional stress, intentional interference of a business relationship, intentional misrepresentation. These are different types of intentional torts where you do need to prove that element of intent. Um, know the difference between pure comparative fault, modified or partial comparative fault, and contributory negligence. Pure comparative fault means that even if someone's 90% at fault, they could still recover the remaining 10%. Where modified or partial comparative fault means if they're over 50% at fault, then they're barred from recovery. And then contributory negligence means that even if they contribute at all, if they had 5% contribution or they assume the risk, then they will be barred from recovery. Usually, it's about negligence or intentional towards. They could test this concept of uh, respondeat superior, where an employer can be held liable for the acts of the employee so long as they're within the scope of business, for detours but not frolics, that third party liability or maybe non-delegable duties in some senses. I really like torts essays. Think about intervening and supervening events which could cut off liability, the eggshell plaintiff rule, where you'll find a plaintiff as you find them. I mean, yeah. Um, a lot of cool pieces to torts that I think you just have to remember. It's mostly negligence. What is the duty owed? It's a reasonable person under similar situated circumstance, how they'd be called to act um if they were ordinarily prudent, like a child of similar sensibilities to another child, right? There's a nuisance claim. A nuisance could be like if there's a interference to that's not uh, due to a heightened sensitivity, right? It's reasonable interference. These are some thoughts for different torts. I think torts is super manageable as long as you know the different claims of action. Then you should be able to address the issues on test day. I think starting with contracts and torts, as I start my classes every year, eh, because they're super manageable subjects. Um, Con law, it's not super heavily tested on the MEE, but if it is tested, it would be, due process, equal protection, First Amendment, freedom of speech, freedom of religion, freedom of press, freedom of petition, freedom of assembly, different scrutiny levels, strict scrutiny if it's fundamental rights. If it's 14th Amendment, equal protection, it'll be targeting a suspect class or a quasi-suspect class or an unprotected class. So, strict scrutiny, the government must show that the action is necessary to achieve a compelling interest, is narrowly tailored, and the least restrictive means possible. Whereas intermediate scrutiny, the government needs to show that it's substantially related to an important government interest. And the rational basis test means that the plaintiff has to show that the action is not reasonably related to a legitimate government purpose. So remember, First Amendment also has freedom of speech, and freedom of speech could be strict scrutiny if it's content based, or high intermediate scrutiny if it's content neutral, time, place, and manner restriction, where it's narrowly tailored to an important government interest and leaves alternative avenues of communication. The Fifth Amendment has the due process of notice and hearing, right? Procedural, and then substantive due process, deprivation of life, liberty, and property. That's also where we get the takings clause. So you think of like a regulatory taking if legislation renders property economically unviable or deprives the owner of their investment back expectations, or a possessory taking if there's a eminent domain or condemnation that takes private property for public use. So common law says the 10th and 11th Amendment. The 10th Amendment is state sovereignty, preemption, anti-commandeering. And the 11th Amendment is sovereign immunity, where an individual cannot sue a state unless they're suing that state actor in their individual capacity for injunctive relief. And then the state cannot sue the federal government, but the federal government can sue the state. And then I could talk about 14th Amendment applies due process to the states and also is equal protection. Maybe you could talk about the Commerce Clause, where Congress can regulate the channels, instrumentalities, and economic activities that in aggregate have a substantial effect on interstate commerce, or the Dormant Commerce Clause, where states cannot discriminate against interstate commerce or unduly burden interstate commerce with their actions or legislations. Remember, there's standing, state action, justiciability. Standing is injury, causation, and redressability. Justiciability is right but not moot. These are some of the key pieces to con law that you might see on the bar exam. And then there's real property. Real property is tough, super tough subject. Deeds. There's general warranty deeds, special warranty deeds, and quitclaim deeds. General warranty deeds have the 6 covenants of the present warranties of size and right to convey and right against encumbrances, and then the future warranties of further assurances, general warranties, and quiet enjoyment. Remember that a contract can merge into the deed, and there's the implied warranties of marketable title, and those warranties mean that there's no encumbrances on the property, there's no mortgages, no liens, no threats of litigation, no strange zoning ordinances or anything like that. There's adverse possession, where you can acquire title to property if it's open, continuous, exclusive, adverse, notorious, hostile, and for the statutory period. There's with color of title and without color of title. With color of title means you have some deed or document purporting title. Without color of title means you don't. If you do it with color of title, then you can uh, you can acquire everything that you was described in the deed that you had, even though it was defective, so long as you actually occupied some of the land. If you didn't occupy any of the land, then you can't acquire anything in the deed, right? But if you have color of title and you occupied some of the land, you can recover all that's uh, described in the deed. Without color of title, it's just whatever you actually occupied, right? Um, so that's adverse possession. There's easements. So there's express easements, implied easements, easements in gross, easement in pertinent, uh, easement by prescription, which is similar to adverse possession, just without the exclusivity. And then easement by necessity, when property is landlocked and it is hemmed in and has no access to a public road. And then easement that are affirmative and easements that are negative. Negative easements would be like riparian rights, water rights, or right to a view or something like that. So yeah, they test like adverse possession, they test easements, they test deeds, maybe mortgages a little bit. A mortgage is a loan secured by property that in the event of non-payment will lead to a foreclosure action, which is the forced sale of the property, which will pay off the senior mortgagees. And then the junior mortgagees will need to seek a deficiency judgment from the homeowner. Um, Real property, super tough subject. It could be landlord-tenant issue potentially. Landlord has the duty of habitability and quiet enjoyment. Tenants have the duty to pay rent and not commit waste. Waste could be actual, like affirmative, or permissive, or ameliorative, like it actually helps the property. Maybe they can get into fee simples, but I don't really see it. And like types of estates, like the feasible fees, like fee simple determinable, is by duration with automatic reversion. Fee simple subject to condition subsequent is with conditional language and allows for the right of reentry. And then executory interest could be a shifting executory interest from grantee to grantee, or a springing executory interest from grantor to grantee. Um, Real property contracts have to be in writing to conform with the statute of frauds. A real covenant or an equitable servitude. Real covenants are remedied by legal relief. Equitable servitudes are remedied by equitable relief, but those are promises tied to land, and they'll run with the land if they touch and concern the land. There's notice, intent, it's in writing, and there's some element of privity. Um, you know, types of tenancies. There's tenancy in common, tenancy by the with right of survivorship, and tenancies by the entirety. A tenancy in common is presumed. In tenancy in common, there's two parties, A and B, and if B were to die, then B's heirs would take B's portion of the property. A joint tenant with right of survivorship means there's A and B, and if A were to die, then B would survive A, and B would take the entire property. So that's a JTROS. So, if you devise, your portion in the lifetime, that would sever the JTROS and turn it into a tenancy in common. So if A and B had JTROS and B devised his stake to C, then A and C would have a tenancy in common. If A and B had a JTROS and B bequeathed his property to C in the will, well, the JTROS would prevail over the will. So you can convey your interest in a JTROS during your lifetime, but you're not going to be able to bequeath it in a will because a JTRS will prevail over the will. And then tenancy by the entirety is simply a joint tenancy with right of survivorship plus marriage. Some jurisdictions require a straw man, which means that you have to convey it to a third party and then he conveys it back to the couple so they can satisfy the element of time when it comes to the unities of a JTROS. A joint tenancy of right of survivorship requires the four unities of time, title, interest, and possession. So civil procedure is a pretty tough question, pretty tough subject. PJ, SMJ, and venue. PJ would be where the parties are domiciled, and remember, companies are domiciled where they're incorporated and where their nerve center or headquarters is, their principal place of business, and individuals where they live and intend to stay. There's the minimum contacts test, where you can look at factors such as relatedness, traditional notions of fair play and justice, and contact with the forum state, and see if they have minimum contacts to establish general or specific jurisdiction. Also, in accordance with the long arm statute of the state, so that they can be hailed into a court. If they purposely availed themselves of the law and it's systematic and continuous, it would be general jurisdiction. If it's just their contact led to the injury, or the injury arose out of their contact, like a car accident, then it would be specific jurisdiction. It could also be by consent or by being tagged, right, being served within the state. SMJ, so you'll have federal questions or diversity will allow a case to get into federal court. And there's also supplemental jurisdiction. Supplemental jurisdiction means that if a case gets into federal court on its own, and there's another case that arrives out of the same transaction or occurrence, right? The common nucleus of operative fact, then the federal court has discretion to exercise supplemental jurisdiction over that case as well. The defendant can bring that case in with no regard for diversity, but the plaintiff cannot. If the plaintiff tries to bring that party in via supplemental jurisdiction and it destroys diversity, it would not be valid. Remember, supplemental jurisdiction is discretionary, and if there's a claim that's in federal court on its own, and then they bring in an additional claim via supplemental jurisdiction, and then the original claim gets dismissed, Well, now the federal court will have discretion to either to continue to hear and adjudicate the supplemental claim or to remand it back to the state court. Remember, only defendants can remove, and the forum state defendant rule. So a defendant who's sitting in diversity cannot remove upward in his own jurisdiction. If a federal question arises under the Constitution or a treatise or something like that, then removal is proper, always. So then there's venue. Venue is proper where the cause of action accrued or where any of the defendants reside if they all live in the same state, or in absence of any of that, where they could have personal jurisdiction over the parties, over the defendants. So yeah, there's PJ, SMJ, venue, there's transfer of venue. We talked about in my last lecture for conflict of law. It's pretty interesting that if you transfer venue, you're not transferring choice of law. You're just transferring the venue, but you'll still use the choice of law from the original location. And also note that you can only transfer venue if venue was originally proper and you're transferring to a venue that would be proper as well. Think about the life cycle of the case. Like you could have a judgment on the pleadings very early on after the complaint and the answer, or the counterclaim and the answer to the counterclaim. You could have a 12B motion to dismiss. And remember, 12B6, motion for summary judgment, dismiss for summary judgment can be brought at any time. I'm sorry, 12B1, 6, and 7 can be brought at any time. Motion for summary judgment, 12B6 is motion for which relief to motion to dismiss for a claim for which relief cannot be granted is 12B6, and then 12B7 is failure to join a necessary indispensable party. Those can pretty much be brought at any time, whereas the other ones, PJ, venue, process, service of process, they need to be brought at their first opportunity. They're going to be waived. So you, like we said, judgment on the pleadings, maybe you have an affirmative defense, like they're a minor to a contract, that has to be brought pretty early. Then later, after discovery, you can have summary judgment, and the standard is there's no genuine disputed material fact. After the other party presents evidence, you can move for a JMOL, judgment as a matter of law. And then after the verdict, you could move for a new JMOL or a new trial or an appeal, or eventually, after up to a year, relief from judgment. So understand the life cycle of the cases is pretty helpful. There's Rule 11 sanctions, and remember, if the opposing party moves for Rule 11 sanctions for filing a frivolous claim or something like that, they have to comply with the safe harbor provisions and give time for the opposing counsel to amend or to rescind their complaint or their motion or whatever it may have been. Claim preclusion versus issue preclusion. Claim preclusion means there's been a final judgment and it's the same party, same configuration, and the claim will be precluded from relitigating. It's known as res judicata, whereas issue preclusion is more narrow and it's the actual issue, and it can be offensive or defensive or mutual or non-mutual depending on the jurisdiction. Non-mutual means that a new party is allowed to assert the issue preclusion. Remember, issue preclusion means actually litigated, and then claim preclusion is a final judgment. There's compulsory counterclaims and permissive counterclaims and permissive cross claims. Cross claims are the same part, like same side of the V, let's say, whereas counterclaims are against the V. Cross claims are always permissive. Counterclaims are compulsory if they arise out of the same transaction or occurrence. They need to be brought or they'll be barred, subject to res judicata. Also, voluntary dismissal 2 times in federal court leads to preclusion as well, that you can't bring it back a 3rd time. The Erie doctrine means that in a diversity case, we need to apply federal procedural law and state substantive law. Procedural law means order of witnesses, whether or not you have to submit to a trial, whether or not they get a jury, preclusion, relation back. These are things that are procedural. Substantive is like damages, statute of limitations, elements of the claim itself, like what's the standard, or what's the persuasion or the presumption, right? Presumptions would be substantive. So if you're going to apply substantive law, you apply the substantive law of the state where the federal court is sitting, where it was filed, right? If it's a choice of law, you apply under Claxon the choice of law of the what we would call the Erie state, the state where the federal court is sitting. You apply that state's choice of law. So that's a Claxon analysis, Erie analysis. It's only for diversity cases. If it's a federal question, you apply federal procedural and federal substantive law. For evidence, usually they're testing hearsay, exceptions, exemptions. Hearsay is an out-of-court statement proffered into evidence in order to prove the truth of the matter asserted. There's statement against interest require unavailability, whereas party opponent admissions is just a party or party opponent or one of their privies. The business record exception means that the statement was made in the regular course of business and not in the anticipation of litigation. There's the dying declaration, which at federal law can only come in if they're unavailable and it's a civil case or a homicide case. For evidence to be relevant, it has to have a tendency to prove or disprove a controverted fact. And for it to be reliable, it has to survive the 403 balancing test, and its probative value cannot be outweighed by its prejudicial value. So those are some key pieces to evidence. Maybe there's qualifying an expert witness using the Daubert standard, that we have to show that they're respected in the field with different publications or educations or experiences. On a case-by-case basis, the judge will be the gatekeeper for that. Remember, questions of admissibility are for the judge, and then their relevance will be or their weight of the evidence will be for the jury. So question of admissibility for the judge, the weight of the evidence for the jury. Evidence, I would recommend maybe looking at the Federal Evidence Code or the Florida Civil Procedure Code. If you're nervous about those procedural subjects, I think looking at the actual codes themselves can be helpful down the stretch. After we did evidence, I'm gonna have to look at my classroom. Sorry. Shoot. After we did evidence, I have to look at my classroom and see what we even did. I think I've done it in order so far. We started with contracts and torts, and then we did MPT, MEE, and then we did the backward, but whatever, property con law, civil pro evidence, all right, agency partnerships, corps and LLCs. Okay, great. So, for agency and partnerships, I was pulling up this guide because I didn't want to miss these concepts because I think they're pretty solid. But agency, we have the principal and the agent, we have the mutual assent and the capacity, co-agents, co-principals, sub-agents, things like that. And then authority, actual authority means that, they are authorized, could either be express or implied, right? And then apparent authority means that the third party reasonably believes that they have authority, or then inherent authority means like part of their job. And then ratification is when a principal can ratify the acts of an agent. And then we talked about this disclosure. If the principal is disclosed, the agent will not be liable. But if their principal is partially or undisclosed, then the agent and the principal could be held liable. Right. Those are just some key pieces I want to talk about when it comes to partnerships, and they always seem to test them, that implied authority, express authority, and that master, principal agent relationship. and things of that nature. There's definitely respondeat superior, which can come up in torts as well, but that's employer-employee liability, and they'll be liable for the detours within the scope of business, but not for the frolics, which will be considered outside the scope of business. When it comes to partnerships, think about different duties that they'll have to each other, like duty of loyalty and duty of care. Remember that a partnership uh, arises without a formal agreement. It just has to be two or more parties who are um, working together to earn a profit, right? You should have a partnership agreement, but you don't need one, and it doesn't need to be filed with the state. And then for agency partnerships, think about the different types of general partners, limited partners, LLPs, right? A general partner has management responsibility and is personally liable. A limited partner is only liable to the extent of their investment. A general partnership has general partners only. A limited partnership has general partners and limited partners. An LLP, a limited liability partnership, has only limited partners. And then there's the LLC, which is a limited liability corporation, which can be manager managed or member managed. Member managed means the members of the LLC manage it, or manager managed means that the members will hire managers to essentially manage the LLC. LLC files articles of organization, whereas a corporation files articles of incorporation. An LLC is similar to an S corp in the sense that it has flow through taxation and limited liability. An S corp is like a corporation that elects flow through taxation, whereas most corporations are C corps, which have double taxation and limited liability. Corporations have board of directors and shareholders. They test that the board of directors have similar duties of partners and trustees, which is the duty of loyalty and care, not to self-deal, not to usurp corporate opportunity, but they'll be protected by the business judgment rule, meaning that even if they did something that was a little bit, the outcome wasn't perfect, we can protect them by saying that they, were acting within the best interest of the company, so long as there's no showing of good faith. There's the MBCA, right, which governs the corporations and how they should act. Corporations have shareholders, which are stockholders that could be common stockholders or preferred stockholders. Common stockholders are those shareholders who have voting rights. They can vote on the board of directors. They can vote on fundamental corporate changes like mergers, stock splits, acquisitions. They can vote on amending the corporate charter. And preferred shareholders. Preferred shareholders have priority when it comes to dividends, which are declared when authorized, and liquidation priority. So common stockholders have, inspection rights, appraisal rights if they're gonna have a merger or consolidation event. And then the preferred shareholders have the dividend priority and liquidation priority. Yeah, I think some of the key concepts there were like the business judgment rule. They test a good amount, and then just knowing the different rights of shareholders in a company and things like that. There's something called piercing the corporate veil, which means that if you can show that the company just serves as an alter ego for the shareholders or for a subsidiary company, and there's an improper purpose or thin capitalization or some reason that we could subordinate the rights of the shareholders because they're essentially operating a fraudulent business via the protection of a corporation. So that would be piercing the corporate veil, going after a parent company or the shareholders directly. there's derivative suits and direct suits. A derivative suit is suing on behalf of the corporation. In order to do that, you have to provide notice to the corporation and file demand that they sue or show that it would be futile. And you have to be an active shareholder, whereas a direct suit is a shareholder suing the company directly. So I also think I talked about corporations and LLCs, and then I went to wills and trusts. Okay, so wills and trusts, that's the week I took off, right? Because Rebecca taught wills and trusts, and wills, will formalities usually have to be attested by two witnesses in their presence, and wills are going to determine distribution, but there could be intestate distribution, which could be per stirpes or per capita. Per stirpes means it's split on the first generational level, whereas per capita means it's split on the first level and who should receive for each let's say branch of the tree beneath you. So like if it's per stirpes, it would be, A dies a widow and has three kids, B, C, and D. D's dead. D has two kids, E and F. Will be split 33% to B, 33% to C, and then 16.5% to E and F, right? Whereas at per capita, it would be split 25% between those four because those are the heads that would take. So that's per stirpes versus per capita. Um, wills, they have some weird questions about like language in wills, like a lapse and anti-lapse. So if property is devised to someone who dies before the testator, then that property is said to have lapsed and will either revert back to the estate or go to the residuaries, be split amongst the residuaries, unless that state has an anti-lapse statute. And you'll look at that anti-lapse statute to see if that were to occur, who should take. Maybe it's a lineal descendant of the grandparent or something like that. You'll file the language of the statute. There was something about like what's the difference between um heirs and beneficiaries, and heirs are like your intestate survivors, and then beneficiaries are like people who are listed in your will. And then there was something about your issue. Your issue are people who come beneath you, like your spawns, not people above you. So, you really gotta look at the language in some of these wills questions and just kind of interpret the question as it's being asked. Trust, remember, it's a testator of a will, it's a settler of a trust. A trust has to have, capacity, a sound mind, intent, be 18 or older, and have trust race, current property, and have trustee and ascertainable beneficiaries. But a trust will not fail for lack of a trustee. The court can appoint one. We'll typically look for settler intent when it comes to trust modification and termination. Trustees, similar duties as the board of directors, right? They have duty to act personally, to act loyally, to separate and earmark funds, and to prudently invest. And just because the value of the trust goes down doesn't mean that the trustee has violated their duties. It's similar to the business judgment rule where they'll be protected. There could be a spendthrift provision. A spendthrift provision will mean that if a outside creditors cannot pierce the corpus of the trust until disbursements have been made, except if it's alimony, child support, or the government. So just trust can be discretionary, where the trustee has the decision to make payouts or not, or mandatory, where the trustee has to make the distributions. The beneficiaries can petition to have a trustee removed if he's creating waste or illegality or change circumstance, or the trust purpose has been satisfied. And trusts are pretty good instruments to distribute property to people past your death, right? Testamentary trust is created upon death, where an inter vivos trust is created during a lifetime. There could be a pour over trust, like maybe it's created in a will or something like that. And then a totem trust, which is like a payable on death account where the funds will transfer from an account and create a trust. Wills and trusts, they can be tough subjects, but I think Rebecca did a really fantastic job. And I wish some of y'all were taking the test in Florida because Rebecca will be there with me in Florida. Me, her, Priscilla, James, some maybe Tara and Amy will all be in Florida. But yeah, Rebecca did a great job, Wills and Trusts. You guys can check out that presentation she made. Let's see. After Wills and Trusts, I did we got to July and we had no class because of the 4th of July. And then we did secure transactions and family law. Okay. So secure transactions, as I told uh Karina before the class, it's about the fundamentals. Attachment, perfection, priority, PMSIs, those are the key things you need to know. Attachment via security agreement, and in the security agreement, it could be it has to reasonably describe, sufficiently describe the collateral. Collateral that's physical could be consumer goods, farm products, inventory, or equipment. You typically attach via security agreement. Attachment is gives rights in the collateral. There's some types of collateral where you can actually attach via possession or control, like accounts receivable or chattel paper or collectible cards or something. So you attach via security agreement and then you perfect via financing statement. The financing statement can have a more generic description of the collateral. The financing statement puts other people on notice of your interest. A PMSI is a purchase money security interest, which is similar to a PMM in real property, a purchase money mortgage. A purchase money security interest means that the money borrowed is used to purchase the collateral, and they'll have second in time, first in right priority, super priority. PMSIs in consumer goods have automatic perfection upon attachment. PMSIs in non-consumer goods like inventory, equipment, or farm products have a 20-day grace period where as long as they perfect within 20 days after attachment, then they'll have super priority. Priority is going to be determined by first in time, first in right. So if it's first to perfect versus second to perfect, the first to perfect will prevail. Perfected versus unperfected, the perfected will prevail. PMSI will prevail overall. There's the concept of a buyer in the ordinary course of business and the garage sale exception, which means like if you buy a TV, at a Walmart or you buy it at a garage sale, and there's a someone had an interest on it, you would be free and clear of it. Think of a buyer in the ordinary course of business like a bona fide purchaser, someone who takes for value in good faith without notice. And then the garage sale exception, yeah, you just take it from a garage sale. How are you supposed to know that there was an interest on that? I think secure transactions, right? If they hold on to the collateral, then you can seek a writ of replevin to get the collateral back. There could be an after acquired property clause, which would mean that anything that, if you perfect or attach, it'll also attach and perfect to anything that's subsequently acquired, like, inventory, further inventory that they get. Usually PMSIs will include the proceeds too of that particular good. Again, I think secure transactions is a scary subject, but if you just understand attachment via security agreement, perfection via financing statement, priority is first in time, first in right, unless it's a PMSI, a purchase money security interest, and PMSIs have automatic perfection upon attachment in consumer goods and a 20-day grace period in non-consumer goods. I think you're going to do much better than most people on that subject. It's a tough subject, but it's just about collateral, inventory, equipment, farm products, consumer goods, and then about having rights in those collateral via attachment security agreement, and then perfecting those rights and putting others on notice via a financing statement that's filed with the state or the county. So I know secure transactions gives people trouble, Article 9 of the UCC, but it's manageable. If you're writing about attachment, security agreement, sufficient description of collateral, financing statement, for perfection, it could be more generic description, and then PMSI, purchase money security interest. If the money borrowed is used to purchase the collateral, you're doing all the right things. So don't be nervous about secure transactions. Family law. I guess I taught family law. Um, Family law, it's about, you know, how are we going to handle divorce? We're going to look at the UCCJEA, the Uniform Child Custody Jurisdiction Enforcement Act, and look for jurisdiction by where the child lived for the past 6 months, or in a divorce case where either party has lived for the past 6 months who's filing. And under the UCCJEA, whichever court created the final settlement agreement will have exclusive continuing jurisdiction over the matters. So think about child support, alimony, parenting plans, these different things that will come into play here. You cannot waive child support in a prenuptial agreement, but you can waive alimony or property and distribution. Equal distribution, or what Diego was talking about, which was community property. I mean, they're kind of similar, but the difference is community property means they'll split the community property evenly. Equitable distribution means they'll split the non-marital property equitably. So equitable distribution means that they're going to have marital property and non-marital property. Non-marital property is property that was acquired before the marriage, or property that was acquired during the marriage, but individually, like it was directly gifted to you or you directly inherited it, right? And then, you'll each take your non-marital property, and then marital property will be divided equitably, considering a litany of factors, length of marriage, contribution, whether there was any adultery or, things like that. Child support, you're really focused on the best interest of the child and the statutory guidelines about how much one party makes and what the needs of the child may be, and taking the child's preference into consideration. Time sharing, custody, it's usually going to be split or some sort of parallel shared. It's rare that they're going to award sole custody unless one parent really is super problematic. Um, yeah, I think, divorces, all states are no-fault divorce states that will allow for a divorce if a marriage is irretrievably broken or a party's been uh adjudicate incompetent for 3 years. The difference between a divorce and an annulment, a divorce means that we're ending the marriage. An annulment means we're canceling the marriage as if it never even existed. And then, like we talked about in the last lecture, the full faith and credit, where we will recognize divorces from other states and will recognize common law marriages that were validly accepted in other states, even if our state doesn't itself validly recognize common law marriages. And then maybe I think something on adoption would be like adopted parents have the same rights as the biological parents, especially when it comes to distribution and things like that. Okay, then the last two subjects were Crim Pro and Crim Law. Crim Pro, it's really much the Fourth, Fifth, Sixth Amendment, the exclusionary rule, the fruit of the poisonous tree, the Miranda rights, right? The Fourth Amendment is a reasonable expectation of privacy, the need for a warrant, and probable cause. The exception to the need for a warrant, probable cause would be if there is the space is mnemonic, search instant to arrest, plain view doctrine, automobile exception, consent, exigent circumstances, and stop and frisk. These are times where you would not need that warrant. The Fifth Amendment protects against, well, there's a lot in the Fifth Amendment. It's due process, and there's the takings clause, but criminally, there's the right against self-incrimination, the right against double jeopardy, and the right to the Miranda rights, your right to remain silent, your right that anything you said will be used against you, your right to an attorney, and if you cannot afford one, one will be provided for you. This is when you're subject to a custodial interrogation, when you're under arrest and you would not feel free to leave. There was a question that we did, an essay that we did about separate sovereigns, right? That like if you're a kidnapper and you kidnap from state A to state B, you could be convicted of kidnapping in state A, state B, and at federal law. You just couldn't then be convicted in the city of state A because that would be double jeopardy. But separate sovereigns would not violate double jeopardy under the Fifth Amendment. The difference between Fifth and Sixth Amendment right to counsel is Fifth Amendment right to counsel is when you're in custody, and Sixth Amendment right to counsel is after charges have been filed when you're subject to when you're subject to charges, and it's offense specific. We talked about one question where there's like suppression of a unreliable out of court statement and an in court statement, and suppression is usually the method for when we have evidence that was seized in violation of the Fourth or Fifth Amendment. Usually, the Fourth Amendment right against unreasonable searches and seizures, or the Fifth Amendment Miranda rights. For criminal law, you want to know all the different types of crime. For murder, the different theories of murder are that it could be specific intent or premeditated malice aforethought. So if a person was cold-blooded, then they could be guilty of first-degree murder. And then the other forms of murder, like felony murder, and the underlying felonies are burglary, arson, rape, robbery, and kidnapping, or intent to inflict great bodily harm that results in death, or a depraved heart murder, which is a reckless indifference towards human life. Then there's voluntary and involuntary manslaughter. Voluntary manslaughter is adequate provocation, heat of passion, warm-blooded murder, like walking in on the pool boy with your wife, or someone slaps you and you stab them back, right? You were imperfect self-defense. And then involuntary manslaughter is like criminal negligence, or a crime that is not a underlying felony for murder that results in a killing. So that'd be involuntary manslaughter, like texting and driving, or speeding and killing someone. So those are different homicide theories. Then there's theft theories, larceny by trick, false pretenses, embezzlement, receipt of stolen property. There's burglary, robbery, right? You want to know these different crimes and their elements and be able to talk about them. I tend to think that the criminal law essay students tend to do very, very well on. Remember specific intent crimes, embezzlement, attempt, solicitation, conspiracy, first-degree murder, false pretenses, assault in the majority of jurisdictions, larceny, fraud, robbery, burglary, and then forgery. I mean, these are some of the specific intent crimes where you need specific intent. There could also be like, general intent crimes like battery in criminal law, and the other forms of murder that aren't first-degree murder. Other crimes besides there's strict liability crimes like statutory rape and things like that. There's inchoate crimes where the crimes will merge with the greater crime if it's attempt or solicitation, but not conspiracy. Conspiracy will stand alone. Conspiracy requires bilateral agreement at common law, but under the model penal code only requires unilateral agreement. So it could be with an undercover agent. One thing I could talk about as kind of crim pro would be the insanity standards, right? There's the McNaughton test where it was a product of their illness that they couldn't tell right from wrong. There's the irresistible impulse test where it was a compulsion that was the reason, and then the model penal code will provide for either the irresistible impulse or the McNaughton test. And then aside from that, there's a Durham test, which is but for the insanity, the incident would not have occurred. I think crim law, crim pro are super manageable. I mean, generally speaking, the subjects that are tested on the MBE are the same on the MEE, and you can just use your knowledge to answer those questions pretty proficiently. The last subject, which I just gave the lecture on, was the conflict of law. And as we talked about, conflict of law is never really tested on its own. The main idea was that the choice of law approach that's most commonly used is the significant relationship approach, where you look to see, where did the injury occur, where are the domiciles, what's the relationship of the parties, and you apply that choice of law. Other than that, it's like you would do like a Claxon analysis under Erie to use the choice of law of the state where the federal court is sitting. For family law, we talked about the UCCJEA, where they'll have, full faith and credit of the other court's recognition. For trust and estates, we said that property is usually governed by the law of the situs where the real property sits. And then personal property is where the testator who wrote the will was domiciled at the time of death. And then contracts can have a choice of law provision that'll usually prevail unless it's super unreasonable. And then for business entities, the takeaway was that the law of the state of incorporation will govern the existence, structure, and internal matters. So it's where the corporation is incorporated, usually in the state of Delaware, that's going to handle disputes. So I think that's every single subject on the MEE. I know that it's a lot of information, but I think you guys can all do, and girls, and every single person taking this test, I think y'all can do amazing on this exam because we've gone through this test, we've prepared ourselves, and there's nothing left to do but take care of business. Things that I would mention are mind your time on test day for the MPT and the MEEs. Try to really keep up your pace. If you start falling behind, finish the next one up quickly so you can get back on pace. Because, like I told you, one incomplete MPT or one totally blank MEE would sink your ship, and we can't afford that. So, make sure that you're mindful of your time and give your best answers. Write as much as you can within the time parameters and then move on. And if you wrote as much as you can and you have nothing else to write, well, then good. You can use that time to allocate towards another essay. But you want to have complete essays for everything. What would I do, down the stretch as the test is right around the corner? For sure, the questionnaires and just articulate the rules of law so that you know exactly what to write on test day. Be sharp, know exactly how you're going to write things when you encounter them, like what you're going to write for an offer, or what you're going to write for negligence per se, or what you're going to write for commerce clause. The exact phrases you're going to use, you should almost start working on them like they're your lines to recite on test day. For the MPT, there's not really much you can do to study unless you want to write another one in practice just to get your timing down. But, just sound body, sound mind, look good, feel good, test good. That's how you start. Just remember the things I told you that like you're not trying to write something that's super well thought out and critical. You're trying to write something that's a sufficient response that's structured as asked and that incorporates all the information that's presented to you. And then for the MEEs, I mean, there's going to be some really hard essays and there's going to be some easier essays. Definitely a low-hanging fruit test. All the things you know and you know well, write as well as you can. And then some things that you encounter that you have no idea, just remember no one else has any idea either. Just take a good stab at it. I've been working with Karina. She submitted her MEE essay and there was a question about like a buyout and whether that it would be necessary after someone had left the partnership, or yeah, have they left the partnership, they disassociated. And the answer there, she was like, I had no idea, but I wrote yes, they'd be entitled to a buyout for their interest. And that was the answer, right? they withdrew, but they were entitled to a buyout. And it was just like she said she had no idea and she was totally stumped by the question, but she ended up writing the exact right response. You'd be surprised how much of this test is a common sense test and is just about staying calm under pressure and just writing articulate responses that, consider the facts. I think a lot of people who never even practice law a day in their life could answer some of these questions and do pretty well. I'm not saying they would pass the test, but I'm just saying there's definitely places where you don't need to rely on your black letter law and your mastery of the Constitution or of real property, and you can rely on just your own life experiences and just kind of do an analysis and come to a conclusion. When you have that, essay and you know the law and you know it well, yeah, it's your time to shine, right? Write the rules and aspire to be like the model answer. But it's a super passable test. I think down the stretch, study the questionnaires. I'll give you advice tomorrow for the MBE, but it'll be study the cram guides for sure. And if you're really like, you're nervous, you're unsure, just read over the model answers and just familiarize yourself with the issues that you might encounter. And even if you're not taking notes or whatever, just read through them for familiarity so that they become, nothing shocks you on test day. At least you've seen it. Just try to put things in your subconscious mind so that at least you have something to write about on test day. And then this is advice I've been giving people all day is don't focus on the uncertainties, right? Do not focus on the uncertainties. I've been teaching for this test, this administration since the results came out in April, right? We did the 2-week essentials course at the end of April. So since the middle of April, I've been teaching for this test. All the, weeds and uncertainties, we've had time, and y'all have been studying probably since May or whatever. Y'all have had time to study a lot of things and go down a lot of rabbit holes and get confused and get unconfused and then get confused again, right? Been there, done that. This is not the time for that. All that stuff that's confusing right now is for the birds, right? Fuck that shit, to say it eloquently. What's important right now is to focus on what you know and make sure you know it well, right? Your bread and butter, the things that you're very confident you're going to be tested on, make sure that you can articulate it word for word and start practicing your lines like you're ready to prepare. It's not the time to be learning new things as much as it is the time to solidify what you already know. So don't be focused on the uncertainties. Try to hammer down the certainties and really be prepared and confident that the things you know well. I've been telling people I don't like when you know something when you see it. Be able to say it presumptively. You know it, right? You know it when you know it. And I'm telling you, there's a difference between memorization and understanding. Some things like dates and times and charts, yeah, just memorize them. But other things, if you actually know it and understand it, like honestly, I do with most of these subjects, you never have to memorize it because you can explain it, right? Like I can explain the game of baseball without knowing the big terms. They have a bat, they have a guy who throws this circle. Like, it's the same thing. I can explain claim preclusion without knowing the big terms. It's like they already did it in court, so we're not going to do it again. It's like what's the point of that? It's already been decided. You know what I mean? Like, so try to really know the things know them well. And then last but not least, give yourself some grace and get ready for test day, right? It's Saturday. It's Saturday evening. Sunday's the Lord's Day, right? Monday's travel day. Tuesday, Wednesday's test day. There's not much time to do much else except for get your mind right, get your body right, and be in a good place for test day. Um, I tend to find that the people who perform the best on test day are the ones who really approach this like a business or like a Super Bowl or like a thing where it's a big event that they've been prepared for, they're excited for, and they show up ready to rock and roll. The people who come in super sweaty, super anxious, super frazzled, hey, that's going to lead to making some careless errors on test day. The ones who are locked in, they got that adrenaline, you can just see it. Like they're not there to socialize. They're not there to like, have a crazy TikTok experience or whatever. No offense to anyone, I'm just saying they're not there for anything except for the task at hand. And then Once you take care of the details, everything else will fall into place. Then you could become the world's most famous influencer. You can become a huge inspiration. You come work for Ibis Prep, be an instructor, be a great tutor. I mean, be a great lawyer. Whatever it is you want to do, the world is yours. But we got to take care of the thing that's right in front of us, which is execution on test day. So you don't want to go into the exam room super tired. You don't want to go in hungry. You don't want to go in not knowing what you're going to do for lunch that day. So, these next couple of days are really the time to smooth things out and make sure that you have all your travel arrangements, all your lodgings, where you're going to be eating and what you're going to be doing at specific times, printing out whatever last minute resources you're going to want, in the testing pre-room or at night or whatever, just take care of all the details tonight and tomorrow. Do some studying, like I said, just gaining confidence, do confidence building activities, going over cram guides, going over questionnaires, reciting laws that you know. Don't really spend too much time looking into the weeds to clarify an issue that you haven't been able to clarify for 4 months already. And then if you're really content and you feel like you know your stuff, I think going into the statutes themselves and the codes themselves sometimes and just reading over the black letter law. One, it'll put you right to sleep, right? And you can all use some rest. And two, sometimes that's like, for me, I remember that being like the final ribbon that I would put on the present, because it was like I spent all this time learning this stuff, watching videos, doing outlines. Then I did all these questions and essays where I kind of was just like, I figured out what the right answer is. But then when you finally look at the code or the statute and you read the language, you're like, oh, that's why, and it all kind of makes sense. I wouldn't start there because it's like it's just too much. But yeah, if you're worried about like, venue or SMJ or, a particular tort, look at the restatement of torts and read about that tort in the restatement. Or if you're worried about, I don't really understand SMJ, go into the Federal Rules of Civil Procedure and go through the, SMJ rules and just kind of, do the one over and read them, not for memorization, not for mastery, just to kind of become more familiar and put more things in your subconscious mind. And these are just some ideas. Other ideas: sauna, steamer, cold plunge, hot tub, manicure, pedicure, massage, spa, right? Treat yourself. Like, let's get ready to feel real good. I'll end you with one of my favorite sayings: look good, feel good, test good. Y'all have studied your asses off. I believe literally everyone in here isn't just going to pass. They're going to pass with flying colors. I have this club called Club 300. So if you score over 300, you'll get a little gift from me and you'll be a part of a cool club for life. And I have no doubt that there's going to be multiple new members of the club this year because we've done a great job. We've really done a great job. Props to Danny for helping organize some of the stuff. Props to you all for showing up. And I'm just really excited for this exam, and you guys should all be excited to take it. So I'm going to go ahead and stop this recording.